previously given secondary disclosure in the Alexander cases. Mr. Alexander is present in custody with us via Zoom. And the matter is before the court today for a pretrial risk assessment. Ms. Bizignani, have you had the opportunity to review that report?
Yes, Your Honor, I have.
And you as well, Ms. Meister?
Yes, Your Honor.
Okay. Anything further from the defense?
Yes, Your Honor. I just wanted to say that just because the alleged victim in this case is a celebrity doesn't mean that Mr. Alexander should be treated any differently than any other defendant. He's innocent until proven guilty, and I realize that for purposes of bail or purposes of OR, that the court assumes that the charges are true.
Thank you.
But even if assuming everything in the pretrial risk assessment is true, what we really have here is a misdemeanor trespass. According to the pretrial risk assessment, Mr. Alexander was told that he was not welcome at the property and entered Ms. Spears' home anyway. There's no information that was provided to the court that this is a felony stalking, which would require that Mr. Alexander willfully and maliciously harassed or repeatedly followed Ms. Spears, and that he made a credible threat with the intent to place the person in reasonable fear for her safety. So my first request in this case is to OR Mr. Alexander, which is the same treatment that any other defendant would get with the same alleged facts. Even if the court assumed that felony stalking was true, the court can take the statement of facts into account when assessing the danger to the public. And clearly this is misdemeanor conduct. This is a trespass, and OR should be set in accordance therewith. Mr. Alexander is not a flight risk. He has no histories of failure to appear. The out-of-county warrant that's listed in the pretrial risk assessment is an arrest warrant. It's not a bench warrant based on a failure to appear. Even though Mr. Alexander was living out of county at the time of this offense, he does have transportation through Metrolink to Ventura County. At the very least, if the court is going to deny OR at this time, I request that the court do it without prejudice and reconsider OR if there's placement found for Mr. Alexander at a local residential treatment facility. Second, if the court is inclined to deny my request for OR, my request is set a reasonable bail for Mr. Alexander that he can afford. The court is aware that according to Humphrey, the seminal case on bail in California, that liberty is the norm and detention prior to trial is the carefully limited exception. Courts are required to make a finding concerning a defendant's ability to pay, and may only set bail at an unaffordable amount if there's no less restrictive terms of release that will suffice. $100,000 is more than Mr. Alexander can afford. Mr. Alexander believes he can afford $20,000 through family support, and he will abide by any conditions that the court sets, including pretrial supervision by probation, a stay-away order, weapons terms, drugs terms, alcohol terms. These should be sufficient terms to ensure public safety and are in fact what the court set just 2 days ago, believing that that would suffice. So setting bail at this amount, it'll strike the appropriate balance by protecting Mr. Alexander's constitutional right for reasonable bail while also protecting the public. So I'm requesting first that the court consider OR, and if the court denies OR, to deny it without prejudice and set a reasonable bail at $20,000.
Anything further, Ms. Bizignani?
No, Your Honor, submit.
Ms. Meister?
Thank you, Your Honor. Your Honor, the people are objecting to the defense request for an OR. We are also objecting to the defense request for lower bail. The people disagree with Ms. Bizignani's suggestion that this is merely misdemeanor conduct. Felony stalking does require a threat to the underlying victim. This victim is not being treated differently because of her celebrity status. The defendant had been repeatedly admonished not to come to this victim's home. He did come to her home repeatedly after being so admonished. And not only did he come to her home and trespass on her property, but he made entry into her residence and made it so far as to her bedroom inside the residence. That, through its course of conduct, is threatening in nature and does communicate a threat to the victim in this case. The defendant, as suggested in the pretrial report, is currently on misdemeanor probation out of state for a similar offense, aggravated stalking, and also has sustained a prior domestic violence conviction out of San Francisco from 2015. The defendant has homeless transient status. He has no ties to this community, as outlined in the pretrial risk assessment. He is unemployed. He, further suggesting that he has no ties to this community. And the people did not ask for some outstanding or outlandish bail. We simply requested the bail that was set forth for the felony charge of stalking in the bail schedule. I don't think that $20,000 is appropriate. I think the defendant has demonstrated through his course of conduct here that he does not really care about an admonishment not to come to the victim's home, as evidenced by the fact that he ignored such an admonishment from her security team and continued to come to that exact residence. If people feel that the bail established by Your Honor 2 days ago, in conjunction with the criminal protective order, is appropriate, it gives the defendant an opportunity to make bail. We are not requesting that he be detained at no bail. And we are asking that Your Honor not modify any of the orders and keep bail as submitted.
The court has read and considered pre-trial risk assessment report prepared by Deputy Probation Officer, Supervising Deputy Probation Officer Eric Webb. I have considered the arguments and comments from Ms. Bizignani as well as Ms. Meister.
Don't adulterate a urine sample that you give for protest. Do not associate with
The court has taken into consideration the defendant's history, his prior convictions, and recent history do include an aggravated stalking charge out of the state of Tennessee, as well as domestic violence convictions. Ms. Meister, the pretrial risk assessment report references a 273.5A felony from 2015, and then domestic abuse battery from 2015. Are those two separate convictions?
Your Honor, I only noted a felony conviction for 273.5 on the defendant's criminal history. I am not familiar with the misdemeanor charge.
Is that a separate and distinct charge involving a different victim than 273.5?
That's my understanding.
Same victim in this case?
Correct, that's correct. That's my understanding.
Does that involve victim in, if you know, the aggravated stalking case from Tennessee?
I don't know, Your Honor. I did not know about the Tennessee matter until this morning.
So it's like contacts can be okay with just all conduct.
So the defendant is currently charged in this case with felony stalking. He has an aggravated stalking conviction in his recent criminal history, along with a felony domestic violence conviction from 2015. The charges in this case, the circumstances outlined by Probation Officer Webb do indicate an exercise of violence upon an individual who attempted to intervene with the defendant's trespass onto the victim's property in this case.
Right. Something. Thank you very much. I appreciate it.
The defendant's reporting of the trespass is pretty brazen as well, which is cause for concern.
Miguel Ventura.
I am also taking into consideration the maximum sentence the defendant faces in this case, the risk to the community, the victim in this case. And Ms. Bizignani, I will note that you were actually the first person who referenced the alleged victim's celebrity status in this case. That was not referenced or considered by the court in my previous ruling from 2 days ago. And I will assure you that that is not something that would cause me to deviate from the treatment of Mr. Alexander in this case. The cause for concern is specific to Mr. Alexander and his criminal history and the alleged conduct in this case. I do not believe that less restrictive means would sufficiently ensure the safety of the victim or others in the community at this time. And the clarity from this evidence before the court is that less restrictive means would not do that.
Mr. Howard came with the sheriff and they came stating that Alan was there. Alan hadn't lived there 5 years.
So considering the seriousness of the charges, the defendant's history, the protection of the public, the fact that this is a second stalking charge close in time to the first, the request for an OR is again denied as Pissignani. The court has also considered the defendant's ability to pay as outlined by Ms. Pissignani.
He told me to bring this about the dog.
Bail will remain as set at $100,000. And Ms. Pissignani, you did reference terms that the court has previously imposed. Those were terms, supervised release terms, should the defendant be in a position to post bail, which he may be in a position to post bail in this case. One term that is required by Penal Code Section 646.93, subsection C in a stalking case that I inadvertently left off. An additional term will include that the defendant, on the request and at the time of his or her appearance in court, shall provide the court with an address where he is residing or will reside, a business address and telephone number if employed, and a residence telephone number if the defendant's residence has a telephone. That is a specific term statutorily required for the charge of stalking pursuant to Penal Code Section 646.93, subsection C5. So that will also be included. Should the defendant post bail, that will be one of the terms of his pretrial monitoring by probation. We do have an early disposition conference date set for June 22nd. Preliminary hearing is June 24th. Last day for preliminary hearing is June 27th. Is there anything further from Mr. Alexander at this time?
Not for the CBI.
No, Your Honor.
Thank you. Thank you. Mr. Alexander, you're finished in court today. You can let the deputy there know you're done in court.